Well, on Good Friday, Donald Trump's legal team filed an appeal on Fulton County Judge Scott McAfee's decision to allow Fannie Willis to stay on the election interference case. An odd decision, many of us thought. The filing in Georgia's State Court of Appeals argues that an appellate court should clarify precedent on the question of forensic misconduct, an act by a prosecutor that requires disqualification under Georgia law. It also argues that McAfee should have found an actual conflict of interest and, barring that, should have disqualified Willis. Lawyers are stating that Willis had been untruthful in her testimony about her and Wade's inappropriate relationship, creating an appearance of impropriety that requires her removal from the case, period. The question now is, will the court take up this appeal at all? We'll all know pretty soon if there's any decency left. Here to discuss this is the senior legal fellow from the Heritage Foundation and former Deputy Assistant Attorney General for the DOJ's Criminal Division, John Malcolm. John, nice to see you.
Good to be with you.
All right. There it is, laid it out. It seems to me, and look, I, like millions of others, watched the testimony of Fannie Willis and Nathan Wade with mortified curiosity, I think would be a fine way to put it. We were just, I just stood there in shock, and I look at this. I don't know how you arrive at any decision that she remains on the case, with him or without him. I don't understand it. What are your thoughts?
Well, so the standards are pretty loose, and the courts in Georgia have not done a lot to elucidate those standards. And Scott McAfee acknowledged as much, which is why he said, look, this is a serious issue, and you can take an interlocutory appeal if you want to. And not surprisingly, the parties have agreed to do that. He was quite candid. He said, look, Nathan Wade has to go or you have to go. And he said that there's an odor of mendacity. That was his phrase about not only her behavior, but also about her testimony. He said these are very, very serious issues. I think the Court of Appeals will likely take it up and clarify this. And I would not be surprised if at the end of the day they say, if this case is ever going to go to trial and anybody is going to have any confidence in the process that was used or the verdict that was obtained, another prosecutor needs to be the person who's bringing this case, not Fannie Willis. But we'll see what the Court of Appeals does. But it's a serious issue. And I'm glad that Judge McAfee has at least said, look, I could be right. I could be wrong. You want to take this to a higher court. I'm going to give you the opportunity to do exactly that.
So, in effect, he punted. And look, Judge McAfee worked previously under Fannie Willis. I mean, he's a former employee of hers, right? I mean, so it's, to me, there are problems all over the playing field here. But what it shows is, going back a few months or a year, roughly, this was the case. This was the case that was going to get Trump. All the other ones, maybe, maybe not. But this was the one that was going to get him, because this is the one that was, airtight. Not so airtight today, is it, John?
Yeah, no, look, I never viewed it as the one that was going to get him. I'm not sure any of these are going to get him. But if I were to pick one, it wouldn't have been this case. I wouldn't say that Scott McAfee punted. He did what he thinks is right, but said, hey, this is an unclear area. I could well be wrong. Take it up. Scott McAfee is a former prosecutor. I know people down in Georgia where I used to practice. I was a federal prosecutor down there for a number of years who actually think highly of him. I think he's trying to do his best, but certainly Fannie Willis has made her bed and she can lie in it. And if anything happens and she ends up being disqualified, she'll have no one to blame but herself. And it wouldn't surprise me if at the end of the day, that's what happened. And I think there is no way that this case is going to go to trial before the election. That's for sure, if ever.
If ever. And John, one last thing. Having listened to the testimony, which I did, it seems to me that she did perjure herself. I mean, we've got the cell phone records. We've got the money that went back and forth. We know where he was 35 times at the apartment down there. How could she have told the truth? These things, they don't add up. And so that's where the casual observer that's not an attorney, a person like myself, says, how is this even possible? I'll give you the last word.
Yeah, look, I agree with a lot of what you said. Certainly the cell phone records about how many times they were in communication before he was appointed appear to be pretty damning. I mean, a lot of her explanation is stuff you can't prove. I kept cash in the house. I paid cash for all this stuff. very difficult to refute definitively, and which is why I think the judge said something doesn't smell right. Odor of mendacity are pretty strong words to use. He certainly could have gone so far as to disqualify her. I think in his view, he sat there and said that would be quite something. It would have the case reassigned to another prosecutor or possibly begin the process all over again. He was just not prepared at this time to take that dramatic a step, but the Court of Appeals might. In the meantime, Scott McAfee is considering motions to dismiss various charges in the case. He's already dismissed some, so he's going to keep doing his thing, and the Court of Appeals will do its thing.
And it's a process. The courts never move rapidly, do they? At least it's a rare occurrence when they do. There's no chance this makes it before November. I think you're right about that, if ever, because it's one appeal and then it grinds along and then it's another problem, then it grinds along. It's a process, but it's not a fast one. John Malcolm, thank you for being here.
My pleasure. Good to be with you.